Mabuhay! Today, we will be discussing two cases, one of which is General Register number 212690 for civil case application and the latter is the General Register number 209601 encompassing commercial law specifically under the Corporation Code of the Philippines. First to be discussed is General Register number 209601. In this case, United Coconut Planters Bank or UCPB is the one who filed the case or is the petitioner against Secretary of Justice, Office of the Chief Prosecutor, Tirso Antipodra Jr. and Gloria Carrion, which are the respondents. As for the facts of this case, on July 2006, UCPB filed a case against private respondents Tirso Antipodra and Gloria Carrion for violation of Section 31 in relation to Section 144 of the Corporation Code of the Philippines, wherein Section 31 of the said law states that total yearly compensation of directors should not exceed to 10% of the net income before income tax of the corporation during the previous year. Under the same law, Section 144 states that the penal sanction should be automatically imposed on violation of provisions for which no criminal penalty was done. All of this happened because the respondents Antipodra and Carrion were formerly the UCAP's CEO and COO, a wholly owned subsidiary of UCPB. Now, in year 1998, Antipodra and Carrion authorized the payment of bonuses to some of UCPB's corporate officers and directors amounting to almost 118 million pesos. Now, because of these substantial losses, UCPB's Board of Directors decided to shorten the corporate existence of UCAPs effective on March 1998 and approved the takeover.
When UCAP was absorbed by UCPB, they saw that UCAP had debts amounting to 4.4 billion pesos, all because of Antipordas and Carrion's bad decision to release a bonus for directors. UCPB claims that this is gross negligence and in violation of their bylaws which requires a board authority prior to declaration of bonuses. Thus, Antiporda and Carrion are liable under Section 31 of the Corporate Code, which provides for the liability of directors who conduct the affairs of a corporation in bad faith. And Antiporda and Carrion are criminally liable under Section 144, which provides for penalties for violation of the Corporate Code. The court ruled Section 144 was not applicable to violations of Section 31 of the Corporate Code, and the action against Antiporda and Carrion had prescribed. As it held, the penalties in Section 144 of the Corporation Code apply only when the other provisions of the Corporate Code do not provide penalties, since Section 31 provides for the remedy of civil action of damages. Section 144 does not apply anymore. The petitioner could have easily won the case if they defined Section 31 and 34 as offenses instead. Because of this, the petition is hereby denied by the court.
So today we're going to discuss about the General Register number 212690, spouses Romeo Pajares and Aida T. Pajares, the petitioner, versus the Remarkable Laundry and Dry Cleaning, represented by Archimedes G. Solis, petitioner. According to Judge Del Castillo, breach of contract may give rise to an action for a specific performance or rescission of contract. It may also be the cause of an action in a complaint for damages filed pursuant to Article 1170 of the Civil Code of the Philippines. In the specific performance and rescission of contract cases, the subject matter is incapable of pecuniary estimation, hence jurisdiction belongs to the regional trial court. In the case for damages, however, the court that has jurisdiction depends upon the total amount of the damages claimed. 2012 Remarkable Laundry and Dry Cleaning filed a complaint denominated as breach of contract and damages against spouse Romeo and Aida Pajares before the RTC of Cebu City. Respondent alleged that it entered into a remarkable dealer outlet contract with the petitioner whereby the latter acting as a dealer outlet, shall accept and receive items or materials for laundry, which are then picked up and processed by the former in its main plant or laundry outlet. Violated Article 4 the standard required quota and penalties of said contract, which required them to produce at least 200 kilos of laundry items each week. The respondent made written demands upon petitioners for the payment of penalties imposed and provided for in the contract that petitioner's violation constitutes breach of contract.
In June 29, 2015 resolution, this court resolved to give due course to the petition, which claims that the CA erred in declaring that the RTC had jurisdiction over respondent's complaint, which, although denominated as one for breach of contract, is essentially one for simple payment of damages.
The petition is granted by the court. The civil case number was appropriately classified by the RTC CEB 39025 as an action for damages seeking to recover an amount below its jurisdictional limit. In the contrary, respondents' counsels designated the complaint as one for the breach of contract and damages, which is a misnomer and an inaccurate. This erroneous notion was reiterated in the respondent's memorandum, wherein it was stated that the main action of CEB 39025 is one for a breach of contract. There is no such thing as an action for breach of contract. Rather, breach of contract is a cause of action, but not the action or relief itself. Wherefore, the petition is granted in the December 11, 2013 decision and March 19, 2014 resolution of the Court of Appeals CAGRCEBSP number 07711 are reversed and set aside. The February 19, 2013 order of the Regional Trial Court, Branch 17, Cebu City dismissing civil case number CEB 39025 for lack of jurisdiction is reinstated, and so the petition is granted by the court.